There is a deal inside the United States Treasury right now, and if your name isn't Trump, you will never get it. No audits, no investigations, no tax claims, ever. A sitting Treasury Secretary was asked, under oath, if this has any precedent in IRS history. He could not name one. He was then asked if the government received anything in return. He refused to answer. Senator Whitehouse, a prosecutor who has gone after people for exactly this, looked him in the eye and said, "What goes around comes around." What you're about to see is a cabinet secretary running out of answers, live, on camera, before the United States Senate.
Thank you, Senator Whitehouse.
Thanks very much, Secretary. Welcome. Have you identified any precedent in Treasury or IRS history for the agreement not to audit, investigate, or pursue any tax claims against the Trump family or businesses?
I can't identify any precedent where 400,000 tax returns, including the people you just mentioned and all of their employees, were leaked in a violation of one of the most sacred duties of the IRS.
So let me cut to that then.
Senator.
The leak was by a contractor. Can you tell me what contribution is being sought by Treasury or by the IRS for the harm done by the contractor? To a certain extent, your organization and the IRS are the victim of the contractor's malfeasance or negligence. What is being pursued by way of contribution by that contractor?
Well, the ranking member chastised me for cutting the contractor's contracts off, and we have removed their contracts, their ability to do business with Treasury and the IRS.
But there is no contribution into this particular case.
Again, Senator, you weren't here earlier, but I'm unable to discuss most of this because of ongoing litigation.
Yeah, I know everybody likes to say that, but the constitutional...
We like to follow the law, Senator.
And the law is that the Congress has constitutional oversight functions that do not disappear simply because there is litigation, however convenient it may be, by way of providing answers. So we have no precedent for it. No contribution is being sought from the contractor at fault. Was there any consideration to the government in return for the benefits of no audit, no investigation, no challenge or pursuit of refunds or other penalties?
Again, Senator, I'm unable to comment because of litigation. Treasury is represented by the Department of Justice in all matters. They act as our attorneys, so I would suggest that you direct your questions to Acting Attorney General Blanche.
Yeah, well, I've had a lot of times people who are before us invite me to ask my questions of somebody who's not before us, but you're the one who is before us, and I think you ought to know if there was any consideration offered or paid in return for that settlement. It's a very simple fact question. Was there or was there not consideration?
Again, there's ongoing litigation, and I suggest that you speak with the Treasury attorneys.
If this kind of behavior is okay with the chairman, I'll just pursue other questions. But, what goes around comes around in terms of dodging questions.
I believe it's very clear that witnesses of any kind cannot discuss ongoing litigation.
They can certainly discuss a fact that they are aware of. The fact that there is some litigation out there doesn't mean that a witness can't say, yeah, there was no consideration, or yes, there was consideration. Was there a defense analysis memo? It's referenced in the judge's decision in Florida. Was there a defense analysis memo prepared by the IRS? And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all. I've been a lawyer all my life. I have some idea of what is protected when you have a ongoing bit of litigation. Whether this individual has seen an official memo from within his own department is a very simple question to answer, and I think it's completely inappropriate to have this game of dodgem be pursued without any consequences. Well, last of all, here's another question. Was there any analysis of what harm befell President Trump from having his taxes released when every president since Nixon released their taxes, and he had promised to? Did anybody analyze whether there was actually any harm at all to him in those circumstances?
So there was a crime. President's rights under 6103 of the IRS code was violated, and equally as important, 400,000 taxpayers had that right violated, including every employee of the Trump administration, the housekeepers at Doral, the greenskeepers, and the cashiers.
And you're welcome to pursue all of that, but it doesn't answer the question of whether the president actually suffered harm. And you're not answering that question either.
Senator Cortez Masto.
Okay, let me validate what you probably felt watching that. Because the correct reaction is somewhere between, is this real? And why isn't everyone talking about this? And here's the thing. Bessent is counting on you to feel confused enough to move on. So let's not do that. Let's start with the setup, because the context here matters more than people realize. A contractor with IRS access leaked the private tax records of roughly 400,000 people, including the Trump family, their employees, housekeepers at Doral, groundskeepers, cashiers. That is a real crime. A serious one. Nobody in that hearing room was defending the leak, but here's what Bessent desperately needs you to believe. That this story is about the leak. It isn't. The story is about what happened after the leak, because in the wake of that breach, a settlement was reached between the IRS and the Trump family, and the terms of that settlement are unlike anything in the recorded history of American tax enforcement. No audits, no investigations, no pursuit of refunds, penalties, or tax claims against the Trump family and their businesses, full stop. And Senator Whitehouse, a man who spent his career as a prosecutor before he ever set foot in the Senate, asked the Treasury Secretary one question. Has this ever been done before? Bessent could not name a single precedent. I want you to sit with that for a second, because we're not talking about a minor procedural accommodation here. The IRS is the agency that will garnish your wages over a $1,200 mistake on your tax return. The same agency that audits working-class filers at rates that have historically exceeded the audit rates of the ultra-wealthy. The same institution whose entire constitutional purpose is to make sure that the law applies equally to every American, regardless of who you know, what you own, or who you helped get elected. And the secretary of that institution just admitted, under oath, that he cannot point to a single time in American history where any family received what this family just received. That's not a policy disagreement. That's not partisan optics. That's the definition of a two-tiered system being built in real time, right in front of us. Then Whitehouse moved to the contractor. He asked a simple question. Is the government pursuing any financial recovery, any contribution at all, from the contractor whose negligence caused this breach? The answer was no. Now, I want you to think about what that actually means in the real world. If you hired a plumber who flooded your basement and caused $50,000 in damage, that plumber would be liable for the harm. You don't get to say, oh well, the water's already there, and then sue the neighbor instead. Basic tort law. The contractor caused the harm. The contractor bears responsibility. But instead of pursuing the contractor, the government's response was to hand the affected party, the sitting President of the United States, an arrangement that no ordinary American would ever receive in a million years. Tell me what that looks like to you, because from where I'm standing, it looks like protection money flowing in exactly the wrong direction. Then came the word that made the whole room shift. Consideration. If you're not a lawyer, here's what that means and why it matters so much. In contract law, consideration is the exchange that makes an agreement legally binding. I give you something, You give me something. That's a deal. Without consideration flowing both ways, you don't have a legal agreement, you have a gift. So when Whitehouse asked whether the government received anything in return for this settlement, anything at all, he wasn't being dramatic. He was asking the most fundamental legal question you can ask about any agreement. What did the American people actually get out of this? And Bessent refused to answer. Not because he couldn't, because he chose not to. He said there was ongoing litigation. He said to go ask the acting attorney general. He essentially said, "Don't ask me, ask someone who isn't here." And that is the moment where Whitehouse stopped being a senator and became a prosecutor again. He looked at Bessent and said, "I've been a lawyer my whole life. I know what ongoing litigation covers, and this isn't it." He's right. Let me explain why. The ongoing litigation shield is a real and legitimate legal protection in very specific circumstances. Witnesses should not discuss active legal strategy. They should not reveal privileged attorney-client communications. Fine. But Whitehouse was not asking about strategy. He was asking about facts. Did consideration exist? Yes or no? Have you personally seen a defense analysis memo that your own department produced? Yes or no? Those are factual questions about a cabinet secretary's own first-hand knowledge of his own department's actions. A sitting senator cannot be told by a witness to go ask someone who isn't in the room because that's not how constitutional oversight works. And this is the part of the hearing that I don't want you to scroll past. The executive branch cannot use the existence of a lawsuit as a permanent shield against congressional inquiry. If that were allowed, any administration could protect itself from every oversight question simply by making sure there was always some litigation running somewhere in the background. You would never have to answer for anything. To anyone. Ever. The chairman's defense of Bessent, that witnesses categorically cannot discuss ongoing litigation, was so thin it barely qualified as an argument. It was a curtain, and everyone in that room could see what was behind it. And here's what gets me. Senator Whitehouse, toward the end of his questions, said something that didn't sound like a threat, but absolutely was one. What goes around comes around in terms of dodging questions. He wasn't being petty. He was naming a structural reality about how oversight collapses when accountability is optional. When cabinet secretaries discover they can walk into a Senate hearing, refuse to answer factual questions, and leave without any consequence, the mechanism breaks. And once the mechanism breaks, it doesn't just affect this hearing, or this family, or this settlement. It tells every future administration exactly how much they have to answer for, which is nothing. Let me be clear about what this settlement represents beyond the political noise. If the IRS can agree, in writing, not to audit or investigate a specific family, and the terms of that agreement are kept hidden behind litigation claims when Congress asks about them, then we no longer have an independent tax enforcement agency. We have a tool. And the question of who gets to aim that tool, and at whom, and in exchange for what, that is the question Senator Whitehouse was trying to get answered. He didn't get an answer. Bessent walked out of that hearing room with every question unanswered, protected by a chairman who let it happen, and a litigation shield being used in a way that a room full of lawyers immediately recognized as improper. The IRS settlement may or may not survive the courts, but what happened in that hearing room will not be fixed by any court ruling, because what broke in that room was something quieter and more dangerous than a legal violation. What broke was the assumption that someone, somewhere, is accountable. Democracy does not collapse in a single dramatic moment. It retreats, one unanswered question at a time, one protected witness at a time, one compliant chairman at a time. If this mattered to you, don't let it be a clip you watched and forgot. Share it with someone who still thinks these hearings are theater. Subscribe for more breakdowns like this one, because these are the moments that quietly decide what kind of country we're living in, and most people never even notice they're happening.